Good morning. My name is Ron Warzen. I'm of counsel to Warzen LLC. I've been involved in litigation, both large and small, for approximately 40 years. And this morning I'd like to discuss the phase of litigation that comes immediately after the investigative stage, that is, filing the complaint, and then if one is the defendant, answering the complaint as to whether or not the allegations in the complaint are true. Many lawyers view this stage of the litigation as rather routine, but it's far from routine, and it's extremely important that not only the plaintiff gets the allegations of fact right, but also that the defendant answers the complaint in a proper way. Focusing on the defendant has essentially three choices in terms of how to respond to a factual allegation against the defendant. The first is admit the fact as true. The second is deny the fact. And the third is, I don't have enough information to form a belief as to whether or not it is true or false at this time. Now, as I say, a lot of lawyers view this as a routine step in litigation, but let me use a concrete example to illustrate why this phase of litigation is very important. I handled a piece of litigation a number of years ago that seemed to be fairly straightforward on its face. The case involved a number of plaintiffs who had lent substantial sums of money to a corporation. That indebtedness was evidenced by notes tendered by the corporation to the plaintiffs. There were also personal guarantees that issued in connection with the indebtedness, which were signed by one of the principal shareholders of the corporation. At the pleading stage, my clients pleaded these notes and the personal guarantees as evidence that the principal shareholder owed them significant amounts of money. The defendant answered the complaint and admitted that these notes were authentic, that the personal guarantee was authentic, and the sums were due and owing. Now, there were other issues involved in the case, which ultimately led to a 3-week jury trial. At the conclusion of the plaintiff's case, the defendant moved to throw out a number of the plaintiff's claims based on the fact that these plaintiffs had not shown up and personally testified about the facts and circumstances relating to the notes, the loans, and the personal guarantees. The judge refused to dismiss the case, even though the plaintiffs had never shown up, based solely on the fact that the defendant had admitted that these notes and personal guarantees were authentic and the monies were due and owing. So there you have it, a concrete example of why the complaint and the answer to the complaint can be extremely important in litigation. If you have any questions about any of this, please feel free to call any of the lawyers at Warzen LLC, and we'd be happy to help you. Thank you.